So today was the date scheduled for hearing, and there has been a consent order for conditional dismissal. It says here that the pass-through rent is due and owing in the amount of $5,150 plus court costs, $246.10, for a total amount due of $5,396.10. The defendant to pay $1,800 or more on or before the 6th of September, and another $1,800 on or before September 20th. Defendant to pay the balance in full by October 4th, and the defendant waives the 56-day rule. Is that complete and accurate as to the agreement that you all have? Ms. Bankhead?
Yes.
Okay, and so you understand that you have the right to be represented by an attorney for this?
Yes, I do.
You want to waive that right?
Yes.
You also have the right to proceed to trial. You could have demanded a jury trial. You understand that?
Yes.
And you want to waive that right as well?
Yes.
Is anyone threatening you to waive these rights?
Yes, thank you.
Is anyone coercing you to waive these rights?
No.
Okay, you understand, you have 3 business days from today's date to return to the court. If you realize you misunderstood these rights, you can return and request to have this set aside, okay?
Okay.
Lastly, partial payment or performance of this agreement will not keep this case dismissed. So you have to do exactly what you were going to say in section 3 of this, making the payments on or before the dates that you said and the amounts that you said you were going to pay. If you don't, the plaintiff can request judgment to enter against you, and you will be removed from the property, and you will not get a new court date. You understand that?
Yes.
Do you have any questions for the court?
No, I don't.
Any additional matters, counsel?
Nothing further, Your Honor. Thank you.
Thank you. You're all set.
Thank you.
Thank you.
Thank you.
Oh,
Your computer's messed up. They're recording. The docket you sent me this morning? Oh, yeah. I'm trying to figure out how we get new stuff. No, it did. I see it.
Oh,
It does
okay.
have it on. You have to restart your computer. Yeah. Thank you. I just wait. Restart. To restart the computer. Twenty-one fifty-nine LLC versus Elizabeth Hackney, 25-04546. Appearance, please. Appearance. I said appearances, please. I'm just waiting for appearances.
Oh, Louis Crenshaw, 2159 LLC, representing plaintiff.
Sierra Oliver, P 7707 for defendant.
Okay, today was the date that was scheduled for a hearing, and we attempted to previously put an agreement on the record. I believe Ms. Hackney needed additional time. Are we moving forward with that same agreement today?
Yes, Your Honor. Ms. Hackney had additional time. And we had some discussions about this, and she was consenting to the agreement.
I don't know why the appearance is just not one. This is the- I'm trying to see if we- Agree with this one. I don't see them being a copy today. Okay. It's a consent judgment. It says rent to retain possession is due and owing $2,660. That you'll pay that or vacate the property in question no later than the 20th of September. Is that correct? It says,
I'm sorry if I may correct. It was that she will vacate the property September 20th.
okay, she's gonna pay, she's gonna vacate by the 20th, correct?
Yes, Your Honor.
Okay. There is a money judgment that's gonna issue as well, that you owe $2,660, correct? And the plaintiff is waiving their right to court costs, correct?
That's correct, Your Honor. The, address the court.
Yes.
Yes, in this case, 4B is checked there. You will note, and this is not a matter of paying.
She's just gonna vacate.
Yes, ma'am.
Okay, very good. Okay, ma'am, you understand your right to proceed to trial in this matter?
Yes, ma'am.
You could have proceeded to jury trial, or you could have waived jury trial, had a non-jury trial, but at the time of trial or hearing is when you would have presented any counterclaims or any defenses that you believe you had to withholding the rent. You understand that?
Yes, ma'am.
You want to waive your right to have a trial?
Yes, ma'am.
So you want coercing you to do this and enter into this consent judgment?
Yes, ma'am.
Who's coercing you?
Oh, no one. I'm sorry.
Okay. You have 3 business days from today's date to return to the court. If once you leave here, you realize you misunderstood your right, you would return to the court, request to have that set aside, okay? Do you have any question at this time?
No, ma'am.
Any additional matters for the record, counsel?
Oh, Your Honor.
Nothing further, Your Honor.
Thank you, you're all set.
Thank you very much.
Thank
No
you.
problem. The record in the matter of 3031 versus Marco Rosas. This is 25-04590. Appearance, please.
Good afternoon, Your Honor. Norman Whitty appearing on behalf of plaintiff 3031 LLC.
Hey, Marco Rosas,
Yes.
someone else coming up with you? Oh, okay, great, very good. Okay, today was the date that was scheduled for a hearing, and this is for non-payment of rent. I do have a consent order for conditional dismissal that would dismiss the case today upon the condition that you pay the past due amount of rent, $1,070.85, plus court costs of $162.90 for a total amount $1,233.75. That's the rent due through a period of the end of August, correct?
Yes.
And it says that you'll pay that order before September 8th, correct?
Yes.
Okay, you understand, sir, that you didn't have the right to be represented by an attorney?
Yes.
Do you want to waive that right today?
No.
You want an attorney to represent you?
No.
So you want to waive the right? Okay, you also have the right in this matter to proceed to a trial. You could have demanded a jury trial. You understand that, right?
Yes.
Do you want to waive your right to have a jury trial?
No.
Okay, you do not want to waive your right to have a jury trial? I know, you're looking at me. I'm talking to you, he's not. I asked you, did you understand that you had the right to have a jury trial? Do you want to waive that right, or do you want a jury trial? If you don't want the right, you gotta give it away.
Why is it away?
Okay, so that means waiving the right, okay? Is anyone coercing you to waive these rights? Okay, and you're entering into this agreement because you want to enter into this agreement?
Yes.
Okay, you have 3 business days from today's date to return to the court. If once you leave here, you realize you misunderstood the rights that you've given up, you can return back to the court. You would ask, set this aside, okay? Partial payment will not satisfy this, so you gotta pay the full amount, $12.33.75, and you gotta pay it before September 8th, okay? If you don't, Mr. Whitty will have judgment enter against you. You will not get a new court date. You understand that? Do you have any questions? We'll get you a copy. Any additional matters?
Nothing further, Your Honor. Thank you.
Thank you. You're all set. 900 Long Tick One LLC versus Eric, Michelle, and Majesty Powell, 25-04622. Appearances, please.
Good afternoon, Your Honor. Michael Burns, P 87855 on behalf of plaintiff. I was not aware defendant was here when I checked in. He not checked in, and I don't know.
You are who, sir?
Eric Volume.
Where's Michelle and Majesty Powell?
Majesty couldn't be here. Michelle's ill in the hospital.
Why could Majesty be here?
I should pick up the kids from school.
Majesty is picking up the kids from school,
Yes, sir.
and Michelle, these are both adults?
Yes, sir.
Okay. You can go meet with them privately.
Thank you, Your Honor. May I have the judgment back?
Yes.
Thank you.
Lauren James here. Excuse me. No Lauren James?
Yes, I'm right here. Right here.
Oh, okay. City View Apartments versus Lauren James, 25-04625. Appearance, please.
Good afternoon, Your Honor. Jessica Larson on behalf of plaintiff.
Say with the date scheduled for a hearing. This is for non-payment of rent, and the parties have entered into a consent judgment agreement. Is that correct?
That's correct, Your Honor.
States here that the parties want to consent to judgment against you, that you would pay the past due amount rent, $4,635 plus court cost $264.43 for a total amount for $4,899.43. Correct?
Correct.
That you'll pay that, or you'll vacate the premise no later than the 8th of September, correct?
Correct.
You're also agreeing to have money judgment enter against you, where the total amount due plus court costs is owed in the amount of $4,670.39, correct?
Correct.
Okay. You understand that you have the right to be represented by an attorney today?
Yes.
Do you want to waive that right?
Yes.
You have the right to proceed to trial. You could have demanded a jury trial. You understand that?
Yes.
Do you want to waive that right?
Yes.
Anyone forcing you to do consent judgment today?
No.
Okay. You have 3 business days from today's date to return to the court. If once you leave here, you realize you misunderstood your rights, you can request to have this judgment set aside, and we'll set this matter for a hearing, okay, ma'am? Your copy of your paperwork. Do you have any questions? Any additional matters, counsel?
No, Your Honor.
Thank you.
Thank you very much.
Is Deasia Alexander here? Okay, that's Mr. Visconti, okay. On the record, in the matter of Fountain Place versus Deasia Alexander, 25-04717, appearance, please.
Or good afternoon, Your Honor. Robert Visconti, P61756, the claim.
And you are Ms. Deasia Alexander. Today was the date scheduled for hearing for non-payment of rent. Did you resolve it? Okay. There's a dispute about something?
Yes,
You believe you had a lawful reason to withhold the rent?
yes, I was under the impression that, section 8 was paying, but I didn't think I owed it that much. So I was.
Okay, let me stop you, let me slow you down a little bit for me. So you believe that the past due that's owed is the responsibility of section 8?
Yes.
Okay,
No, it's just.
You believe it was the responsibility of section 8 to pay it? Is that yes or no?
Yes, yes.
Okay, and so you're disputing the amount owed?
Yeah,
Okay, what is the total past due?
Not past due right now before court costs, Your Honor, is $551.54.
$551.54. You said section 8 was supposed to pay that?
yes.
Okay, and you ready to proceed?
Your Honor, unfortunately, I do not have a manager here today. So I believe that Ms. Alexander mentioned something about speaking to an attorney.
Yeah.
You're gonna hire an attorney?
No, I was gonna do legal aid or something.
Legal aid was here at pretrial. Did you meet with them then?
No, I didn't.
Why not?
I'm not really familiar with the course. I didn't.
So you mean you're not really familiar with the courts? We don't have a system set up for you to use that excuse because at your pretrial, we play a video. I, like a broken record, say the same thing every Wednesday morning. We have legal services here to meet with you, not with him, with you, to see if you want to be represented for free. And 99% of the time, you all are too busy to meet with legal services. The reason why we do that is so that you don't get here during today and say, well, I want an attorney. Because if you got the majority of you all can't afford an attorney to represent you for an eviction or non-payment of rent. Some people can. I don't believe in your case that you would be able to afford an attorney. And so legal services was here. They set aside time. They send representatives here to do intakes to see if you're eligible to be represented by them. And you squandered the opportunity for whatever reason.
Sorry.
So now you want to request an attorney. Okay, well, we don't have court-appointed counsel here. This is not a criminal matter. Legal services, I haven't even seen them today, except for this morning in my pre-trials. So now would be on you to try to get in contact with legal services, which is not always easy, to see if they can now do an intake and see if they can represent you. There may be someone from legal services in one of the other courtrooms today because everyone's doing eviction, but I don't know. But you're gonna have to now get in contact with them. And then if they're not able to take your case at this point, you still need to be prepared to present your case at the next court date. I'll give you a next court date. And that's also because he also doesn't have his witness here today, okay? So neither of you are prepared to proceed. And so We're gonna get you a new court date. If you believe that legal service, if section 8 was supposed to pay your rent, you need to bring proof or evidence to support that. And then you can go and see if there's anyone here from legal services in the building. I'm not sure, or you can take their contact information and you can call them and see if you can get an intake. Let them know you missed your intake at the pretrial and you need assistance, okay? September 17th at 2:45. September 17th at 2:45. That gentleman.
That's my father.
Okay. He lives in the property with you?
No.
He was trying to get your attention to tell you something, but then he just left out frustrated. I don't know what it was, but you probably want to talk to him. He can't do what he was doing in the courtroom because that's not appropriate. And he doesn't represent you, so he can't speak on your behalf. But if he wants to communicate something to you that you maybe forgot or should have extended to the court, you can just come back in here and let me know, okay? We'll get you a notice to appear. Any additional matters, counsel?
Thank you.
Thank you. Are you ready on your matter now? Back on the record in the matter of 900 Long versus the Powell, Eric Powell, Michelle Powell, and Majesty Powell. How are we proceeding? It looks like it's going to be a consent judgment as to Eric Powell, correct?
Yes, Your Honor.
And then we have to default Michelle and Majesty Powell. That means they're automatically evicted.
No, Your Honor.
I didn't ask you to talk over me.
I'm sorry.
If you're defaulted, that means they're automatically evicted. Whether or not he executes a judgment is up to him. If they fail to appear, that gives him the right to execute the judgment because they didn't come to court. And if they had something that they needed to do, they were to make other arrangements or try to get here so that we can resolve this. But that's what he put on here. That was your intention?
No, Your Honor. The intention of the default judgment is to act in accordance with the consent judgment. He would not be consenting for them, but the default judgment would take the same terms as the consent judgment, Your Honor.
However, with a default judgment, the judgment automatically enters against them.
Yes, yes.
And that was what I said. They're automatically, they can't default to the terms of this. They're automatically evicted if there's a default entered by the court. And you can go in within 10 days and get a judgment against them to get them execute the judgment to remove them from the property.
Our firm has never done that.
I'm not asking if your firm has done it before, but
I
that's what the law allows you to do if they're defaulted.
And that may be true, but they're not automatic. And I'm not arguing with the court, but they're not automatically evicted. There's a judgment immediately entered against them. But to be evicted, there would have to be an order of eviction. This is just a judgment against them, not an order of eviction against them.
I'm very clear on that.
Okay.
Do you think that he's clear on that?
I've explained to him that it's our intent to act in accordance with the terms that we've agreed to, which is a consent judgment with him, Mr. Powell, and a default judgment with the same terms as the consent judgment.
I understand that, but that's his intent. What I'm going to tell you again is that they are automatically evicted because they failed to appear here. He can do anything when he walks out of here. He can go ahead and request to have a execution on this judgment within 10 days because they did not appear. They have the right, though, to come back to this court and request to set aside the default judgment against them because as long as they can provide me with a good cause of the meritorious defense because they failed to appear. When anytime you fail to appear in court, a default can be entered against you automatically. If it's an eviction, evicting you or putting you in a place of an eviction. Do you understand that? Because he's got to go back and communicate this to his family. And I recognize that you all had a side discussion about the intent, but they're not a party to this, to any discussion or any agreement because they're not here. Do you understand that?
Yes, next question, Your Honor.
Yes.
But that's not his intent, correct?
That's what he said. He said it's not his intent.
Okay, I just want to be clear.
But there's plenty of times that one thing is said that it's not an intent and it happens later. I don't know that it's gonna happen here. But what I'm telling you is they fail to appear. When you don't appear to a civil matter, you automatically lose. Do you understand that?
Yes, ma'am.
And that's the representation you need to bring back to your family
Okay.
for failing to appear in court. Do you understand that?
Yes, ma'am. Can I ask a
He is
question?
not your attorney. He is the attorney for the plaintiff. You understand that?
Yes.
You have a question.
Yes, ma'am. So does that affect me and his agreement
It
outside?
does not affect your agreement with
That's
him.
important to me.
Yes. But you were here. You all have entered into a judgment by your consent that you will vacate the property by the 22nd of this month.
20th of this month, Your Honor.
It definitely says 22nd.
If it's my chicken scratch, I apologize, but the parties wrote down the 20th. I asked Mr. Powell to confirm that.
Yes.
Okay, and so you're gonna vacate by the 20th of this month, and I'm assuming the intention is for your family to leave when you leave, correct?
Yes, ma'am.
Okay, and so you understand that you did have the right to be represented by an attorney today. You understand that?
Yes, ma'am.
You're waiving that right?
Yes, ma'am.
You also have the right to move with a hearing or a trial. You could have demanded a jury trial. You understand that, right?
Yes, ma'am.
You want to waive that as well?
Yes, ma'am.
You have 3 business days to return to the court to request to have this set aside. If you realize later you misunderstood your rights. Do you understand that?
Yes, ma'am.
That 3 business days has nothing to do with Michelle or Majesty. That's yours because you have a consent judgment. You understand that?
Yes.
Okay. If they would like default judgment set aside, they have to come in and file a motion to set aside the default. Do you understand that?
Yes.
We'll get you a copy of your paperwork. Any additional matters for the record,
No,
counsel?
Your Honor, thank you.
You're all set. You're welcome. So what about the issue? Chimney coverage. Sign this, send this to Officer Brooks first. The other policy, let's see.
Okay.
Okay, on the record in the matter of.
What's that?
Let me make sure.
Oh.
David to Jeff. Hey, check it.
Somebody make a popcorn. Right.
For real.
No, we gotta go.
Are you serious?
Is this a test or?
We're seeing if it's an actual emergency.
Wait a minute, babe.
The signal you have just heard indicates a report of an emergency in this building.
It is so.
Thank you.
Looks like the second one we had.
Thank you.
I know she was looking like.
Okay, let's see, this is South Washington. Okay, I have South Washington Park versus Albert Keaton and all other occupants 2504756 appearance, please.
Good afternoon, Your Honor. Jeff Flug appearing on behalf of plaintiffs, South Washington Park.
And you're Mr. Heaton, correct?
Yes, ma'am.
Okay, today was the date that was scheduled for a hearing. I have a consent order for conditional dismissal. It states that the parties are agreeing to have the case dismissed upon payment of the past due, or the agreement that the past due rent will be paid $470 plus court costs of $177.04. That's for rent due through the period of August 31st, and for a total amount of $647.04, correct?
Yes, ma'am.
It says that you, sir, agree to make monthly rent payment by the 5th of each month plus $150 on September 5th, October 5th, November 5th, and December 5th, plus $47 by January 5th, correct? You have the right, sir, to be represented by an attorney. Did you understand that right? Did you want to waive it? You also have the right in this matter to proceed to trial. You could have demanded a jury trial. Do you understand that? And you're willing to waive that trial right as well? And is anyone threatening you or promising you anything to get you to waive that right? You understand that partial performance will not satisfy this agreement? So that means you have to do exactly what you said you were gonna do, making the payments as you said you would make them if you want to keep this case dismissed. Do you understand that?
Yes.
You have 3 business days to return to the court and request to have this set aside if you later realize you misunderstood your rights, okay? Do you have any questions for the court? Any additional matters for the record, counsel?
I know, Judge.
You're all set, thank you. No. South Washington Park versus Makieta Clemens and all other occupants, 25-04755. Appearance, please.
Good afternoon, Your Honor. Jeff Clute appearing on behalf of South Washington Park.
Okay. Oh, okay. And you are Makieta Clemens?
Yes.
Okay, today was the date scheduled for hearing for non-payment of rent. I have an agreement here that the case will be dismissed upon a payment of $380 for past due rent plus court cost of $177.04 for a total amount due of $557.04, correct? Okay, and that's for rent due through a period of the 31st of this month, and that you'll pay that before the 5th? Okay, you understand that you did have the right to have an attorney represent you today? You want to waive that right? I can't hear you.
Yes, ma'am.
Only she can speak. Do you want to waive your right to an attorney today? Okay, you have to say it so the record hears you.
Oh, sorry, yes.
Okay, you also have the right to have a trial. You could demand a jury trial and let the jury decide if you owe this money. You understand that? Do you want to waive your jury? Or do you want to have a jury trial? Okay, and no one's forcing or threatening you to do that, correct? The lady in the back's not making you do this? Okay. You have 3 business days from today's date to return to the court. If once you leave here, you realize you misunderstood the rights that you've given up, you can return back and request to have this set aside, okay? Lastly, partial performance or partial payment of this agreement won't satisfy. You gotta pay the 557.04 by the 5th, because if you pay 557.03, you didn't satisfy this, and they could evict you for that. You understand that? So you gotta pay the full amount by the date you said you would, okay? We'll get you a copy of the paperwork. Any additional matters for the record?
No, yeah.
Thank you. You're all set. Let's see, that was, I did hear.
As I know, I have Freddie Brown and
Here.
that one requesting 28-day adjournment because he does have promises to pay the full amount and we should be paid off in full by then.
So you're requesting how much?
I would say my assumption would be 3 weeks should be enough to have, make sure those promises to pay actually come in and then dismiss the case.
Okay, you applied for assistance?
Yes, ma'am.
Through whom?
Michigan and City of Lansing.
Okay, did you provide proof of that to the clerk's office?
Yes, ma'am.
You're Mr. Brown?
Yes, ma'am.
September 24th. September 24th at 1:30. Get your notice and you'll be all set, okay?
Thank you, ma'am.
Thank you.
Bring it back to you.
We see Anika Shepherd.
I still need to talk to her, but Mr. Holmes is here and we're also requesting a 28-day extension of everything.
Wardell Holmes,
Yeah.
for the same reasons,
Yeah.
same date, same date and time. September 24th at 1:30. Okay, sir?
Thank you, sir.
You just work date. Do you have any questions? You know, this in just a moment. That was the dog face.
Right back.
You're good.
Thank you. On the record in the matter of Michigan Home Rehab versus Leroy Thurman and Courtney Holland, 25-04146, appearance, please.
Good afternoon, Your Honor. Robert Atkin, attorney for the plaintiff.
Your name, sir?
Roy Thurman.
Well, where's Courtney Holland?
When the alarm went off, I ran downstairs with my daughter and I told her to go and get my son. That was my fault.
Well, then I'm not able to enter anything with her, because she's not here.
That's what I was gonna bring the court's attention, Your Honor. If we could set the matter for some time, it might be anyway, but sometime after September 25th, and he actually abides by that, I'll just dismiss anyway, so.
Okay. After the 25th of September? October 8th at 1:30. October 8th at 1:30. Get your notice to appear. Do you have any questions at this time? Okay. Counsel.
Thank you, Your Honor.
I'm just waiting for Mr. Klug for one more, is that?
Mhm.
Here. Mrs. Shepherd, Leroy Furrow versus Anika Shepherd, 25-0475, appearance, please.
Good afternoon, Your Honor. Jeff Booth appearing on behalf of plaintiff Leroy Furrow.
Your name, ma'am?
Anika Shepherd.
Okay, there was a date scheduled for hearing. This is for termination of tenancy. How we proceed?
We discussed this matter and we're going to discuss this matter without prejudice.
This is yours, so. Do we have dismissals over there printed? We should. Okay, okay, we'll get you a copy of dismissal in just a moment, okay?
Okay.
Yeah, my handwriting is the worst.
Okay.